Are the majority of DUI cases in Washington settled by a plea deal? Attorney Antonio Garguile explains. The vast majority of DUI cases in Washington state settle and do not go to trial. Instead, there is usually a compromise between the prosecution and the defendant that both parties can accept. This is generally known as plea bargaining. Without plea bargaining, the court system would be crippled with the backlog. In 2019 alone, there were 29,972 new DUI charges filed throughout the state of Washington. Of those, only 1.8% of the DUI charges went to trial. A more sobering statistic is that only 0.34% of individuals charged with a DUI in 2019 were found not guilty after trial. Also, 10,743 people, 35.8%, pled guilty to a DUI in 2019. These numbers are not promising. This stems from the fact that if you have a breath or blood test over 0.08 and you can't get the result suppressed on some legal reason, winning at trial on a DUI is very difficult. This is the reason why DUI attorneys try to work out deals with prosecutors. In 2019, 12,558, or 41.9% of individuals charged with a DUI, made a plea deal with the prosecutor. This means that their DUI charge was reduced to a lesser charge, such as a negligent driving, first degree, or reckless driving. If your DUI attorney can work out a deal with the prosecutor and get you a lesser offense, it will be very beneficial in the long term by avoiding the consequences that a DUI carries.
At Garguile Law, we help real people deal with real problems. At Garguile Law, we exclusively represent individuals facing driving-related criminal and civil charges.